Welcome everybody. My name is Professor Charles Szymanski from the University of Białystok Faculty of Law, and I'll be giving a short lecture to international trade law and social rights. The United States and the European Union have relatively high labor standards and environmental standards. With globalization and the moving of production and manufacturing to other parts of the world, this has created something of a crisis. Other parts of the world outside of Europe and North America don't have the same environmental and labor protections, and yet European and American businesses are going there, maybe even for that reason, to take advantage of these lower regulatory standards. But as we know now with climate change, often things that happen in one part of the world affect us in another part of the world. For example, with environmental damage. What happens in China affects what happens in the United States and Poland. So there has been an attempt in international trade law with free trade agreements to link these things, to make sure that parties and states that have free trade agreements with European countries, the European Union, and the United States, they agree to some type of minimum environmental and labor standards in exchange for free trade. There are two models, and we'll talk first about the American free trade model, and then we'll go on to the European Union free trade model. In the American model, labor and environmental issues are put in special side agreements to the original North American free trade agreement. This was a free trade agreement between Canada, the United States, and Mexico. And clearly in that agreement, at the time it was made in the 90s, Mexico had lower labor and environmental standards. And so the idea was, well, how could we raise those while giving Mexico the benefits of free trade? The American model is basically this. In the aspect of labor law, that social right, each country had to follow their own labor law. And so in the case of Mexico, this actually was efficient because Mexico had very good labor laws on paper. In reality, the law was not followed. Why? Because of corruption and lack of resources, perhaps judicial resources. And so what the free trade agreement said was, hey, Mexico, you have to follow your own labor law, what it says. If there were sustained violations, persistent violations in the area of child labor and minimum wage and safety, then by a 2/3 vote, eventually, so 2 of the 3 countries in the agreement, if they voted to take it to arbitration, they could. This is a binding process, binding arbitration. It's like a private judicial system, but the parties have to follow it. There could be a penalty if, for example, Mexico did not follow their own labor law in those areas, to up to 0.007% of trade. That doesn't sound like a lot, but considering the trade volumes that exist, it could be up to $20 million, for example. And so here we saw that, yeah, if Mexico backslides on labor rights, they could suffer some serious financial penalties. And this was one of the first such agreements that did that. Later, there was some progression in the Jordanian free trade agreement with the United States. They talked about the ILO core labor standards, and so there was at least a discussion of that, and we talked about that. No discrimination, no forced labor, no child labor, and also the right to join a labor union, later the right to safe working conditions. That was added. The Central American Free Trade Agreement also talked about these core ILO standards and discussed the fact that these countries, this would be Guatemala, Honduras, Nicaragua, countries in this region, they should not lower their labor standards to attract trade. There was one case, actually, out of the Central American Free Trade Agreement, and in this case, the United States lost. The case took years, I believe at least 7 years to follow, and this is a problem with some of the free trade agreements that we've talked about. They look good, but in practice, they haven't been enforced. As I mentioned, the states have to enforce them. They have to agree, and oftentimes the United States has not taken the lead to enforce them. This is an example in the Guatemala case, and the one case that existed was unsuccessful. In Peru, there was an adjustment where the ILO standards were added, so it wasn't that they strived for it, they had to follow them. And this was a big change that the Americans agreed that Peru and the United States both had to follow the core values of ILO. The Trans-Pacific Partnership, this was an agreement that was negotiated, but President Trump, when he was elected, he resigned from it, but still worth talking about because it added a provision on corporate social responsibility. Multinationals should try to help increase working conditions, better working conditions. Also, there was contingency plans where countries with really bad records of labor rights or no labor laws, like Brunei and Vietnam, before they got the benefit of free trade, they had to improve noticeably their labor conditions in their country. So those were some innovations. The last version of the North American Free Trade Agreement was very interesting from a labor law perspective and social rights. In the auto industry, there had to be sort of a minimum wage of $16 per hour for workers working in the auto industry. This was revolutionary for Mexican workers who were making $1.50 or $2 per hour. So if they wanted the benefits of free trade in the auto industry, this free trade agreement added a minimum wage provision. In the European Union, they've taken a different approach. Parties have agreed to follow the ILO standards, to link free trade and labor standards with sustainable development. If we have children working in the fields or on production, that's just not sustainable. They're not going to school. And there's a lot of good language from the EU model about building civic society, for example. However, for the most part, European Union free trade agreements have not been enforceable by binding arbitration. It's just simply civic society, and it doesn't follow the US model. We could say that that could be good in some ways. We've only seen one case from all the American free trade agreements, so it hasn't been enforced, even though the US has binding arbitration. Perhaps a better model is simply to fund NGOs and civic society to enable countries that have agreements with the European Union to protect their own rights. There's been some recent developments with the South Korea EU free trade agreement where there was a panel that looked at whether Korea had met these minimum labor standards, and this panel basically said they did have some rights to make it enforceable, so there could also be a change in the European Union agreements that they may go in the direction of a US model where these social rights are enforceable. Quick conclusions about all of this. What are these free trade agreements, what do they mean? In one sense, they could be a fig leaf, and this is like a biblical example of Adam and Eve, covering their nakedness by a fig leaf. It could mean that these agreements don't mean anything. They're really just for public consumption in the European Union and in America, not to scare workers through globalizations, to say we have these protections, even though they're not enforced, but they're there. So it could just simply be a political message. Or it could be something meaningful and helpful. The Henry Ford example is the classic one. If you treat workers better and you pay them more, they'll have more money to spend and buy European products, buy Gucci handbags, buy iPhones. And so this is beneficial to the Americans and Europeans if you do ensure that workers throughout the world have some basic rights. Thank you for your attention. I hope this was meaningful for you, and I look forward to seeing you again for the next lecture in this series. Thank you.